This is Barry Zalma on insurance. I'm an attorney who is retired from the practice of law and now spend my time as an insurance claims consultant and expert witness, an author and producer of these videos. Since the tort of bad faith was first created, the availability of punitive damages has influenced and resulted in multiple thousands of lawsuits against insurers seeking tort damages for breaches of insurance contracts. It is important to understand, if you're in the insurance claims business or are a lawyer dealing with the tort of bad faith, to understand how punitive damages are calculated. In a bad faith suit, in addition to damages that make the plaintiff whole and indemnify the plaintiff for bodily injury or property damage, the law also allows an award for punitive damages that are not meant to give the plaintiff something he or she lost due to the tortious conduct of the defendant, but are meant to punish the defendant for conduct that was especially outrageous. The extraordinary damages are assessed because the court believes that the defendant needs to be punished in addition to the damages he or she pays as compensatory damages. Society as a whole is expected to learn that the type of conduct that allows for the award of punitive damages will not be accepted through publication of punitive damages awards. It is meant as a deterrent, just as the death penalty is meant as a deterrent to murder. Even though punitive damages awards are meant to punish the defendant and benefit society, and not the plaintiff, punitive damages awards are paid to the plaintiff. Punitive damages awards have been characterized as a windfall for plaintiffs because they put the plaintiff in a much better position financially than they were before the accident or the breach of the covenant of good faith and fair dealing. Some states allow juries to award punitive damages in any amount that they feel is appropriate. With the right case, a plaintiff could receive a multi-million-dollar punitive damages award. Other states have severely limited punitive damages awards by limiting the types of cases where they can be awarded, or placing statutory caps on how much money a jury or judge can award for punitive damages. For example, lawsuits against medical care providers for malpractice have punitive damages caps in many states. Plaintiffs also receive punitive damages awards from insurance companies that deal in bad faith with their insureds and fail to treat their insureds fairly under the terms of the applicable insurance policy. California's pattern jury instructions provide a method to calculate punitive damages in the Book of Approved Jury Instructions, called BADGI, that instructs the jury to consider 1. The reprehensibility of the conduct of the defendant, 2. The amount of punitive damages which will have a deterrent effect on the defendant in light of the defendant's financial condition. This is BADGI section 14.71. In addition, a defendant can ask that the jury be instructed to consider that the punitive damages must bear a reasonable relation to the injury, harm, or damage actually suffered by the plaintiff. The proposed jury instructions include both subjective and objective components. The first factor, the reprehensibility of defendant's conduct, is subjective in nature. The other two, defendant's financial condition and the relationship to actual damages, are objective measurements. While in the ordinary action for damages, information regarding the adversary's financial status is inadmissible. This is not so in an action for punitive damages. The relevance of such evidence lies in the fact that punitive damages are not awarded for the purpose of rewarding the plaintiff, but to punish the defendant. Obviously, the trier of fact cannot measure the punishment without knowledge of defendant's ability to respond to a given award. A defendant's financial condition has always been relevant to the amount of punitive damages awarded and allowed. After the Norman Conquest in 1066, there arose in English law a system of civil sanctions known as amercements. Because of the sometimes abusive nature of amercements, the Magna Carta prohibited those that were disproportionate to the offense that would deprive the wrongdoer of his means of livelihood. Because punitive damages are intended to punish the wrongdoer, a wealthy wrongdoer should face a higher punitive damages award than a less wealthy party, since the function of deterrence will not be served if the wealth of the defendant allows him to absorb the award with little or no discomfort. In 1991, the California Supreme Court decided a case called Adams v. Murakami that held that a reviewing court cannot make a fully informed determination of whether an award of punitive damages is excessive unless the record contains evidence of the defendant's financial condition. The issue of what constitutes the financial condition of the defendant, since although figures may never lie, liars often figure. To determine what is the true financial condition of a defendant, because numbers can often be easily manipulated, is often difficult and on occasion impossible absent glaring errors in the financial statement parties must be wary of and question estimates of net worth based on the data provided. Careful analysis and the help of forensic accountants as expert witnesses should be utilized if there is any question about the net worth of the defendant, and these experts should be utilized by both the plaintiff and the defendant insurer. The Ninth Circuit Court of Appeals set forth a proposed jury instruction different from California's Badgie as follows. Quote, "If you find for the plaintiff, you may, but are not required to, award punitive damages. The purposes of punitive damages are to punish a defendant and deter similar acts in the future. Punitive damages may not be awarded to compensate a plaintiff. The plaintiff has the burden of proving, that is, a preponderance of the evidence, or clear and convincing evidence, that punitive damages should be awarded, and if so, the amount of such damages. You may award punitive damages only if you find that the defendant's conduct that harmed the plaintiff was malicious, oppressive, or in reckless disregard of the plaintiff's rights. Conduct is malicious if it is accompanied by ill will or spite, or if it is for the purpose of injuring the plaintiff. Conduct is in reckless disregard of the plaintiff's rights if under the circumstances it reflects complete indifference to plaintiff's safety or rights, or if the defendant acts in the face of a perceived risk that its actions will violate the plaintiff's rights under federal law. An act or omission is oppressive if the defendant injures or damages or otherwise violates the rights of the plaintiff with unnecessary harshness or severity, such as by misusing or abusing authority or power, or by taking advantage of some weakness or disability or misfortune of the plaintiff. If you find that punitive damages are appropriate, you must use reason in setting the amount. Punitive damages, if any, should be in an amount sufficient to fulfill their purposes, but should not reflect bias, prejudice, or sympathy toward any party. In considering the amount of any punitive damages, consider the degree of reprehensibility of defendant's conduct, including whether the conduct that harmed the plaintiff was particularly reprehensible because it also caused actual harm or posed a substantial risk of harm to people who are not parties to this case. You may not, however, set the amount of any punitive damages in order to punish the defendant for harm to anyone other than the plaintiff in this case. In addition, you may consider the relationship of any award of punitive damages to any actual harm inflicted on the plaintiff. Punitive damages may not be awarded against a particular defendant. You may impose punitive damages against one or more of the defendants and not others, and may award different amounts against different defendants. Punitive damages may be awarded even if you award plaintiff only nominal and not compensatory damages. Close quote. When considering reaching an appropriate amount of punitive damages, always remember, punitive damages awards are by their nature speculative, arbitrary approximations. No objective standard exists, nor is there a mathematical formula applicable to meet the goal of deterring wrongful conduct. With no objective standards to guide them, and understandably outraged by the conduct of defendant, jurors are free to award punitive damages in any amount. The U.S. Supreme Court, in Campbell v. State Farm, warned of the inherent danger in allowing juries unfettered discretion to assess punitive damages, since such judgments set precedent for excessive awards in future cases. Unchecked damaged awards can cause serious harm to the national economy, bankrupt companies, force companies to reduce workforces, drain municipalities' treasuries, drive up the cost of insurance premiums, and deter individuals and enterprises from undertaking socially desirable activities and risks. And that is why the U.S. Supreme Court has limited punitive damages to no more than 10 times compensatory damages, and expects it to never be much more than 1-time compensatory damages. This video was adapted from my book, Insurance, Bad Faith, and Punitive Damages Desk Book, available from fastcase.com at the fastcase.com bookstore. If you found this video to be interesting or useful, please refer it to your colleagues. It's free. Please also subscribe to my YouTube channel and to my Rumble channel and to my blog so you can be informed about future videos and blog postings. Thank you for your attention.